Be ready? Start. The learned counsel for the respondent. We have examined the argument of learned counsel for the claimants, respondents, and we find that points 3 to 5 have been referred to the larger bench, but they do not deal with the issue where the insurance company has been implicated as a party and has contested the claim before the tribunal. Stop. If the insurance company has been implicated as a party and had contested the claim before the tribunal, then the issue has been referred to the larger bench is not attracted. Stop. The present case is covered under para 8 of the aforesaid judgment, wherein the contingency has been dealt with, and therefore the argument of learned counsel for the claimants respondents that the matter has been referred to the larger bench in regard to obtaining the permission under section 170 of the Act does not hold good, and the parties are to be governed by the finding recorded in para 8 of the judgment, which has become final, and the same has been recorded in respect of point 1 and draws distinction as compared to points 3 to 5, where the insurance company has not put in appearance and had not contested the claim. Stop. It is important to mention here that registered of FIR and filling of the charge sheet against the driver of the said offending bus are not in dispute. Stop. Stanza. Thus, it is clear that adherence to the rule of equality in public employment is a basic feature of our Constitution, and since the rule of law is the core of our Constitution, a court would certainly be disabled from passing an order upholding a violation of Article 14 or in ordering the overlooking of the need to comply with the requirements of Article 14 read with Article 16 of the Constitution. Stop. Therefore, consistent with the scheme for public employment, this court, while laying down the law, has necessarily to hold that unless the appointment is in terms of the relevant rules and after a proper competition among qualified persons, the same would not confer any right on the appointee. Stop. If it is a contractual appointment, the appointment comes to an end at the end of the contract. If it were an engagement or appointment on daily wages or casual basis, the same would come to an end when it is discontinued. Stop. Similarly, a temporary employee could not claim to be made permanent on the expiry of his term of appointment. Stop. It has also to be clarified that merely because a temporary employee or a casual wage worker is continued for a time beyond the term of his appointment, he would not be entitled to be absorbed in a regular service or made permanent merely on the strength of such continuance if the original appointment was not made by following a due process of selection as envisaged by the relevant rules. Stop. It is not open to the court to prevent regular recruitment at the instance of temporary employees whose period of employment has come to an end, or of ad hoc employees who by the very nature of their appointment do not acquire any right. Stop. High courts acting under Article 226 of the Constitution of India should not ordinarily issue directions for absorption, regularization of permanent continuance unless the recruitment itself was made regularly and in terms of the constitutional scheme stop merely because an employee had continued under cover of an order of court which we have described an litigious employment in the earlier part of the judgment. He would not be entitled to any right to be absorbed or made permanent in the service stop. In fact, in such cases, the High Court may not be justified in issued interim directions since, after all, if ultimately the employee approaching it is found entitled to relief, it may be possible for it to mold the relief in such a manner that ultimately no prejudice will be caused to him, whereas an interim direction to continue his employment would hold up the regular procedure for selection or impose on the state the burden of paying an employee who is really not required stop. The courts must be careful in ensuring that they do not interfere unduly with the economic arrangement of its affairs by the state or its instrumentalities or lend themselves the instruments to facilitate the bypassing of the constitutional and statutory mandates stop stanza. The trial court held that the plaintiff has prima facie established prior user of the mark Manikchand by itself and its predecessors stop. It observed that the question whether the assignments relied on from its predecessors by the plaintiff were genuine and are proved to the genuine was a question that could be decided at the trial, and at this prima facie stage there is no reason to discard those documents stop. The documents relied on by the plaintiff prima facie showed prior user stop. After referring to some of the decisions brought to its notice, it held that the plaintiff has established a prima facie case for interim injunction stop. It was further found by that court that the balance of convenience was in favor of grant of interim injunction in favor of the plaintiff restraining the defendants. The appellate court reconsidered the relevant aspects in the light of the arguments addressed before it and came to the conclusion that the trial court was justified in granting an order of injunction by the trial court could not be said to be in exercise of discretion which was either arbitrary or perverse stop. The appellate court observed that the trial court at this stage was not wrong in coming prima facie to the conclusion that the prior user of the mark was by the predecessors of the plaintiff and the plaintiff stop stanza. Regarding the argument based on delay and laches was occurrence, the appellate court took the view that the present action was triggered off by the filing of a suit by the defendants in the High Court of Bombay seeking to restrain the user of the mark Manikchand by the plaintiff, and under the circumstances the claim for interim injunction could not be rejected on the ground of delay and laches when both sides seemed to agree that the marks were similar stop. The appellate court also took note of the number of prosecutions initiated against the defendants under the Prevention of Food Adulteration Act in respect of pan masala and gutkha sold under the name Manikchand, and indicated that the plaintiff would be seriously prejudiced and its reputation affected if the defendants are allowed to carry on their trade in these products under the name Manikchand stop, thus finding no reason to interfere with the grant of interim injunction by the trial court. The lower appellate court dismissed the appeal filed by the defendants but directed the trial court to try and dispose of the suit within a period of 6 months from the date of receipt of a copy of its order stop. At his interlocutory stage, it would not be proper for this court to enter into an adjudication based on the various documents produced before this court, which are not of undoubted authenticity and the genuineness, acceptability and value of which are mutually questioned. स्टॉप ओवर। मैटर की पीडीएफ आपको टेलीग्राम चैनल पर मिल जाएगी।